All right, hello, welcome again. Back at it. The court system, very exciting, very not boring, like the bureaucracy. I'm kidding. Actually, this might be a little more interesting, but I'm not a lawyer here. But let's whiz through this as best we can. Uh, then talk about it here down the road. Um, so the key thing to think about at its broadest when we consider the judiciary in the United States is that the judiciary is really meant to be independent and as apolitical as possible. We know it's not completely independent and it's not completely apolitical. But given that courts serve this essential function of settling disputes and interpreting the law, ideally, you want a judiciary that is independent, which is to say, separate from the other branches, which is why judges we can talk about this when we reconvene, but have lifetime appointments, right? So that's supposed to insulate them from immediate politics in the United States here. But we can't overlook the fact that, like professors, judges are people too, right? I know sometimes you don't think that way, but we are. Professors and judges are people, and we have opinions. We have preferences about what government should do. So that makes the courts and simultaneously your professor friends somewhat political, right? I mean, we try to limit the politicization of what we do here, but we're political beings as individuals, and thus the courts are political institutions too. However, let's think about the judicial process here. The main constraints are the Constitution and the laws, right? And we can look at three broad categories of cases in the judicial process. We can talk about criminal law, which regulates the conduct of individuals, defines crimes, and specifies the punishments for criminal acts which you should not commit. Civil law, which deals with disputes that do not involve criminal penalties. So civil law deals mostly with disagreements between two individuals in the legal system. Say you sue your neighbor for whatever reason, not for doing anything criminal, but for a dispute between the two of you. Contract law, this would be civil law, things like that. We could talk about public law and fall asleep, but this involves the powers of government or citizens' rights. We don't see a lot of major public law decisions coming down the pike. I mean, I guess the last would have been a couple of decisions from the Supreme Court over the course of a few years, about a decade ago, beginning dealing with, say, marriage equality. That would fall under the rubric of public law. So I guess I speak too soon. But anyway, as we move forward here, some things to consider, some fancy words. These are concepts you're more familiar with than you probably realize. I don't know who's heard the word jurisprudence, but it's just a fancy word that relates to legal precedent, right? Not who's the legal president, but legal precedent, prior cases, right? Judges are meant to apply the law following prior decisions in similar cases. So that's why, say for example, when you watch movies or TV dealing with a lawyer of some kind, usually a young, intrepid legal student researching cases, and says, "Oh, I found this case in some state and some time where this was decided, and this is how it applies to our case. So let's argue that." That's jurisprudence. Similar to, or very in parallel with jurisprudence, is this principle of stare decisis, which is fancy Latin, which means let the decision stand. This is a judicial doctrine that a previous decision by a court should apply as a precedent in similar cases until that decision is overruled. And that's just putting a finer point on the notion of jurisprudence. Decisions that are made, once made, are meant to be respected until they aren't. Pretty much every Supreme Court justice sitting on the bench now, when asked about abortion in their hearing, said something about jurisprudence or stare decisis, implying that, oh, I wouldn't vote to overturn Roe v. Wade because it's settled law until the current Supreme Court, well, minus with one change, overturned the Roe versus Wade in 2022. So, go figure. We can talk about these notions and how important they are in the American legal system, the U.S. legal system, and they are until they aren't, like a lot of things. But moving on here, I'm going to try to move quickly and not bore you to tears for more than an hour. But three general types of courts in the legal system here. We've got a trial court, which is the first court to hear a criminal or a civil case. Once that a given case is decided, the losing side can, of course, appeal, and that would go to what we call an appellate court that hears the appeal from a decision made by a trial court. And then if appeal is continued, eventually would end at the Supreme Court, which is the highest court in a state or the nation. I don't like that term. I should have changed that. The central government in D.C., the Supreme Court hears cases on appeal, right? No one goes immediately to a state or federal Supreme Court to decide a case. But that's the hierarchy here of most court systems. So courts, as I say, are generally functionally different. They're functionally different, these three types, but they're hierarchically organized. So I've got the triangle inverted here, looking like a big V, the trial court being the first, then the appellate, and the Supreme Court. This is the federal court system, and the same structure is followed by the state of California. So you can see here how this works. State trial courts, analogous to the term in federal law, is district court, but that would be in effect a trial court. Decisions, if appealed, go to a court of appeals, then to a state Supreme Court you see on the right, and then we can get into how cases make it to the Supreme Court. This request for reviews we'll talk about here in a sec. Continuing on, though, with the organization of federal courts, worth pointing out that most cases are heard in state court. I skimmed, I didn't reread super closely the Lowy chapter, but I think it's like upwards of 80 to 90 particularly criminal cases are heard initially in state courts. Cases are heard in federal court if they involve federal laws, treaties, or the U.S. Constitution. Federal law also applies. Let's say if a crime is committed and is alleged, and the perpetrator crosses state lines, that also kicks the crime from a state court to a federal court. Article 3 of the Constitution gives the U.S. Supreme Court appellate jurisdiction in most federal cases, and it gives Congress the power to create lower federal courts. So that's why if you actually have read the Constitution, Article 3 deals with the judicial branch, but it's short, much shorter than Article 1 on Congress or Article 2 on the presidency or the executive branch, because all of the hierarchical system that exists under the Supreme Court has been created by Congress after the Constitution was ratified. Article 2, we know, gives the president nominating power to federal judges and justices, and the Senate the responsibility to confirm or deny those appointments. So moving on here, for the most part, Congress has assigned original and appellate jurisdiction to federal courts geographically. So there are 94 judicial districts around the country, but only 11 regional appellate courts. So if a federal case, it's going to initially be heard in one of these 94 judicial districts. And then if an appeal is made out of that, then the appeal will be kicked up to a regional appellate court. And I've got a map here I'll show you here in a sec. And then there's a separate appellate court in D.C. that only covers D.C., and that's because a lot of federal crimes are tried in D.C. just because it's the capital and that's the nature of the beast. There's some other specialized federal courts that have nationwide jurisdiction, but usually for particular kinds of cases. The textbook map stresses this. The FISA court was created in 1978. This is the Foreign Intelligence Surveillance Act. Created by that act, created this court. This was big in the news, 15, 20 years ago after September 11th, because the FISA court is a court that exists pretty much in secret and authorizes the federal government to spy on U.S. citizens if need be. And that came about after Watergate, but it was applied heavily, so we think, after September 11th. But anyway, here is the map I alluded to. This is from the Katz-Nielsen text, which you have not had to read, but you can see how the country is somewhat logically, somewhat not logically divvied up here by region and appellate court system. The 11 appellate court systems plus DC, the DC Circuit. California is in the 9th district, which covers a lot of the Mountain West and the West Coast. And it tends to be one of the more progressive courts in the federal system. Moving on here to think about diversity of the federal judiciary. This is straight out of the Lowy textbook. I'm sorry, I kind of awkwardly plugged it in here to the PowerPoint slide. But it gives you an idea, unfortunately not comparatively, say, regarding female judges here. I'd like to know how many males were appointed by all these presidents, but you've got the last 7 presidents here. Biden is not on this list, but going back to Jimmy Carter, you can see it tends to be Democrats, I don't know why, who tend to truly try to bring about greater diversity of the federal judiciary. Carter, Clinton, Obama, all Democrats, all appointed more female judges and justices than any of their Republican counterparts. Same goes for African Americans. The one exception to the rule was George W. Bush, appointing more Hispanics than, say, Bill Clinton. But there you go. The numbers, I think, speak for themselves. Continuing on here, the guy in the middle, hopefully maybe somebody here recognizes him. That's Thurgood Marshall. He argued many cases before the Supreme Court, including Brown versus Board of Education in the early 1950s. And he ended up, after serving as an NAACP lawyer, became the first African-American appointed to the Supreme Court. Moving on to California here. I think we've got about 40 slides, so hang on, but I'll try to keep going quickly. The purpose of the courts in California to provide fair and equal access to justice for all Californians. Makes sense. Also makes sense that this is the largest state system in the United States, hearing about 7.5 million cases annually, with about 2,000 judicial officers, judges, and justices, and lots of employees. So quiz question here. A man is accused of holding up a liquor store in Los Angeles and stealing hundreds of dollars from the cash register. Where is this case first heard? Well, give you a chance to think about it. Pause this if you really need to, because I'm going to move on. This is a state level trial court, right? Criminal act occurring in Los Angeles, nowhere near a state border, right? This is obviously not going to start at a court of appeal anyway, but between state and federal court, this is going to federal court. Shifting gears here, lots of examples from my hometown, which is really 2 large municipalities, Kansas City, Kansas, and then you cross the Missouri River and you're in Kansas City, Missouri. But as occasionally happens, someone, say, commits a murder in Kansas City, Kansas, and afterwards flees to is apprehended in Kansas City, Missouri, whereas this case first heard because of the crossing of a state boundary. This makes federal law apply. I'll give you a couple of other examples down the road here of when you might think state courts would handle a case, but it turns out to be a federal case. Oh, and here it is right now. The Tsarnaev case. This is the brother who survived the I think it was 2013 Boston marathon bombing. He ran off in hiding with his brother. His brother was shot by police, and then they found this guy hiding in someone's boat on dry land, but it was dogs and I think like heat-seeking something or other that found him. But if you commit a crime in Boston, but it also happens to be an act of terrorism, that will get your case kicked out of Massachusetts state court and right on up to federal court immediately. And that's what happened with this guy. So certain hate crimes, certain terrorist acts can immediately go to federal court. And there's often collaboration between state investigators and state courts and or prosecutors, at least, and the federal court system to make that decision. The Supreme Court, obviously, is the most important court in the United States. The Constitution tells us that judicial power of the U.S. shall be vested in one Supreme Court. Great. By law, not by the Constitution, but by congressional decision, the Supreme Court has 1 Chief Justice and 8 Associate Justices. So a total of 9 serve on the U.S. Supreme Court. The Chief Justice, currently a guy named John Roberts, presides over the court's public sessions and gets to speak first during deliberations, and often gets to vote last on cases. The Chief Justice also does a lot of writing of judicial opinions. I stress the question of numbers because we've talked about Franklin Delano Roosevelt, FDR, going back to the 1930s, the Great Depression, the New Deal. FDR pushed a lot of buttons. We know he expanded the role of government in citizens' daily lives in this country. And if you recall, when we talked about Congress and the president, he also vetoed a lot of laws, even though he had united government for most of the time he was president. Well, he was worried about judicial review, which I'll talk about in a minute, and some of his laws being determined by the Supreme Court, which was more conservative than he was, to be unconstitutional. So what FDR wanted to do was to expand the number of justices on the Supreme Court. That was viewed as too political, too politicized, and a bit of a power grab, as it kind of was. So the number of court justices has remained at 9. There was some talk among some circles in 2020 and 2021, late 2020, after the elections were held, and once the dust settled and Biden was declared the winner, there was some worry about an overly conservative Supreme Court that exists as it does for political reasons. I'll maybe flesh that out a bit in a minute. But talk of Biden asking Congress to expand the Supreme Court again in 2021, and that was not taken very seriously by the administration. I don't know how I exactly feel about that. Tradition should mean something because the problem is if the court expands, whoever's the president will pick justices that they would want on the bench. And if you can grow the number and give yourself a larger majority, well, you see where I'm going with this. It's almost a form of institutional corruption, I would say. But anyway, that's an issue because we know how federal judges are appointed, right? Presidents nominate federal judges and the Senate confirms them. There used to be a thing called senatorial courtesy, where the administration would ask the candidates' senators for their approval on the nominee. That helps explain why the Ninth Circuit, based in California, is generally more progressive. It's because it used to be that presidents would ask senators from California in recent years, hey, can I appoint this person? Is this person approved by you informally? And the appointees tended to mirror the politics of their state. The Republicans, I think under Bush 43, stopped doing that in the early 2000s. So now it's, I don't think we'll see as much geography affecting the politics of appellate courts. But that's a thing of the past now. So anyway, moving on here. Since the 1950s, nominees to the Supreme Court have been questioned in depth by the Senate Judiciary Committee. The committee needs to approve appointees and then move on to the Senate floor for an up or down vote. This hyperlink here, accessible in the Canvas module, is a Saturday Night Live clip. It's total satire. It's a total hit job on now Justice Brett Kavanaugh, who was appointed, I want to say, in 2019 maybe. But it's quite funny. Matt Damon plays the role of Brett Kavanaugh. I'll leave it at that. He's easy on the eyes, and it's quite funny. But that's a reality, in part thanks to television, technology, right? We talked about how the evolution of technology has changed the evolution of politics. Some of these nomination hearings have become very intense, very ideological. Going back to the late 80s, this guy, Robert Bork, he's now deceased, but he was appointed by then President Reagan. And I think Joe Biden had something to do with getting him borked, which is a word we use now. It's like defenestrated. The nomination isn't a sure thing. Senate approval in the Judiciary Committee is no longer a sure thing. And it looks like Brett Kavanaugh might have not gained appointment, but he did make it out of committee onto the floor and was named to the Supreme Court. The rules have changed to get around some of this politicization. There used to be a filibuster on all judicial appointments that you needed 60 votes in the Senate out of 100 to move forward on the up or down vote. That's been done away with. And nowadays, while just in my lifetime, 40 years ago, Supreme Court nominees, except for Bork, generally received overwhelming support from the Senate, 80-20, 90-10. And nowadays, they're increasingly slender, 50 some, 40 some, either way. So the rules were changed by the Republicans to make it easier to gain the appointment of Neil Gorsuch under the Trump administration. But presidents generally turn to the sitting federal appellate court judges as appointees because they generally have proven track records that can be read, and they've often been voted on before. So I can't think, I say Harriet Miers here in 2005 was appointed to the Supreme Court by then President W. Bush, and she was his personal lawyer. And that just reeked of nepotism, or cronyism, I guess is the better word. And she ended up withdrawing the nomination herself. But she had not been a federal judge at any level. But maybe Elena Kagan hadn't been a federal judge. Anyway, I'm rambling. But you understand that the process, it's like a lot of jobs. How do you get ahead in your job? Just keep doing it and get selected for a promotion. And that's what happens with most people on the federal bench. Here's a list of the names here. You've got Chief Justice Roberts at the top. And then from there, the other judges here, or justices, on the Supreme Court by prior experience. Elena Kagan was Solicitor General. So that's like the chief lawyer for the federal government. The Solicitor General often argues cases in the Supreme Court, but Elena Kagan had not been a judge prior. That's true. My thought was correct. But you can see there are justices on the Supreme Court appointed by 5 different presidents. Most recently, Justice Ketanji Brown Jackson was appointed by President Biden in 2022, the first African-American woman to serve on the Supreme Court. Only the third African-American, Thurgood Marshall, Clarence Thomas, who's still on the Supreme Court. He was appointed by George H.W. Bush when Thurgood Marshall retired. He seems to not be going anywhere. And then Ketanji Brown Jackson, the third African-American to serve on the Supreme Court. And I believe she's only the 1, 2, 3, 4, maybe the 5th or 6th woman to serve on the Supreme Court, period. So there we are. Here's the visual. Increasingly, rightly so, a bit more diverse than it used to be. Obviously, go back even when I was born, it was Thurgood Marshall was the only African American on the court. It was 9 men, and only one of them was not white. Making progress, I believe. Although I will say this, thinking about representation, looking at this photo, I think 1, 2, 3, 4, 5, 6. You're looking at 6 or 7 of these folks are Roman Catholic. Catholics, serious students in Catholic schools do study the law. There's a tradition there. I get it. But I, as an atheist, would kind of prefer there to not be so many folks of one particular religion on the Supreme Court as a just in case. But hopefully as justices continue to retire or pass on, that subsequent presidents will maybe consider that. I don't see myself running for president, so I guess I won't have a direct say in the matter. But partisan politics, right? We've talked about polarization a lot in this class. It affects the Supreme Court as well. Here's a photo of Dianne Feinstein, who passed away in September of 2023. She was a fixture on the Judicial Committee in the Senate for quite some time. And here she is, I believe, at the time, telling Senate Republicans to do your job. This was in 2016. A justice by the name of Antonin Scalia passed away in his sleep in February of 16. And since that was an election year, and since the Republicans controlled the Senate at the time, the leader of the Senate, the Republican majority leader at the time, Mitch McConnell, decided to not hold hearings on President Obama's appointee to the Supreme Court, a guy named Merrick Garland. And this is, again, Dianne Feinstein at the time, 2016, telling Senate Republicans to do their job. But, appointments to the Supreme Court, um, if you've paid attention at all to what's happened since Roe versus Wade was overturned in 2022, presidential appointments are important. Things can definitely, court decisions can definitely affect people's lives directly. And the court has not remained immune from partisan politics. Continuing on here with California judges, a bit analogous to how things are done federally. The governor usually appoints judges and justices. The terms are a bit different in California. Judges oversee trial courts. They become justices at the appellate level and in the Superior Court and the Supreme Court. Again, in the United States system, federal system, justice is a term only used for those on the Supreme Court. Everyone else is a judge. But anyway, higher court justices usually have extensive judicial experience, like with the United States, presidents picking folks from the appellate circuits. Big difference here, and I do think there's a question on the exam about this. 7 justices on the California Supreme Court, a chief justice and 6 associate justices. Remember, 9 on the U.S. Supreme Court, 7 on the California Supreme Court. I'm pretty certain there's a question there on the next exam. Higher court justices are often selected because of their background and general political orientation. Like at the federal level, conservative governors and conservative presidents tend to select and promote conservative justices. And the flip side of that is more liberal governors and presidents tend to select and promote more liberal thinking justices. But nonetheless, judges and justices federally and in California are still expected to be neutral and unbiased in their decision making. Thinking about representation in California, the bench, a general term for the judiciary, the bench skews heavily male and white. This should not surprise you. Unfortunately, this is the reality of lifetime appointments and such. Judicial retention elections occur in California. Not the only state to do this, but this is where voters decide to keep or reject a sitting judge or justice. My home state of Kansas does this too. I don't know. Maybe we could talk about this when we convene for 50 minutes. What you all think about the politicization of voting for judges in effect. Again, California, the governor appoints them, but then eventually, and I don't know what the time frame is, I don't recall, but you voters then decide to vote to keep them or not. But even these retention votes are becoming more politicized and more expensive overall in California, which is a bit of a shame. But I'm not a fan of judicial elections. But again, we can talk about this when we get together. Judicial review. This term has come up in class. I forget what week. It doesn't really matter. I think earlier on in the semester, and I said we'll talk about this when we get to the courts week. This is an important concept. It's important to a democracy. Judicial review is the power of the courts to declare actions of the legislative and executive branches as invalid or unconstitutional. It's a great power that the Supreme Court of the United States has, and by extension, most state Supreme Courts do too. I think it's useful. I think it's necessary. I think it's a good check on the part of the judicial branch on the 2 other branches. However, this hyperly important concept is not explicitly granted to the court in the Constitution. It came about a few years later after the ratification of the Constitution, a couple decades, I guess, in the case of Marbury versus Madison. If you're thinking about going to law school at all, I highly recommend you watch this link. It's under 10 minutes, but I don't think now's not the place for me to go into the details of Marbury versus Madison. Plus, I'm not really an expert. But in a nutshell, this case had to do with Madison, James Madison, the then president, and an appointment, another federal bureaucratic appointment. And there was a contention in how the appointment was made. And instead of siding with Madison or Marbury, in this case, what the Supreme Court did is said the law was bad to begin with. It was something about the root of the problem between the two was unconstitutional to begin with. And that was the U.S. Supreme Court giving itself this right that it hasn't relinquished in 200 plus years to determine the constitutionality of the decisions made in the other branches. So it was a revelation at the time, and most, to my knowledge, pretty much every democracy I've looked at seriously, other than the United States, does have some form of judicial review in its system. It was rarely used immediately after it was created by the Supreme Court in 1803, but in recent decades, and I think this is a consequence of just a greater polarization of the entire country, is we've seen, and I've got some data I'll show you in a sec, the use of judicial review has become much more of a thing, if you will. But judicial review has been used to reverse state actions, overturn federal agency actions, so within the executive branch, challenge presidential actions like signing statements and executive orders, and then to even overturn federal law. And federal law, by definition, would have been a decision, passed through Congress and signed by the president. So this is a real big check because it can simultaneously be used to check two other branches at the same time. And there aren't really any other checks and balances that do that. But here you see, this is from Lowy, Supreme Court rulings invalidating acts of Congress. So going back to the late 17 to early 1800s, that one is Marbury versus Madison. After that, you can see progressively the use of judicial review has increased. And again, it's not an everyday thing. You see 58 times the Supreme Court has invalidated acts of Congress between 1980 and 2019. I'm not a mathologist, but that's like 1.5 a year, around there maybe. So not a lot, but it's still very much a powerful tool that the Supreme Court has. I'll give you an example here. You see the signs being held by these wonderfully angry white people: no amnesty, deport Obama, deport them all, Obama can join them. And then this black guy looking at them, probably wondering what's going on through in their heads. But they were protesting the DACA decision, right? Congress wouldn't pass the DREAM Act to protect the rights of children brought into the United States without documentation by their parents. And both parties, in ebbs and flows over the last 2 decades, have been open to the idea of doing something to facilitate the regularization of such children. But Obama acted via an executive order, which was immediately challenged in court by Republican interests. And the Supreme Court has gone as far as to protect DACA in limited form. Same thing happened a lot with Obamacare. I think there were 3 decisions that made it to the Supreme Court, and each time the Supreme Court has sided with the Obamacare, with the legislation. So judicial review is still relevant even when the court decides to allow the decision to stand, right? It wouldn't come up in this data here of invalidating acts of Congress, but it would be interesting to see how many cases recently have dealt with judicial review, even when the court hasn't overturned the legislation. That's something for me to look up on my own. But anyway, access to the Supreme Court. Let's think about this. The Constitution defines judicial power as extending to cases and controversies, which is to say that the Supreme Court, you can't just ask for a legally binding opinion to be given. Some countries, some international courts do this. Somebody can address the court and ask for an opinion, but in the United States, parties to a case must have legal standing, which is the right of an individual organization to initiate a case. You can't, it's difficult in the United States to bring a case to really any court without you demonstrating how this case is relevant to you, right? So that also limits the role of advisory opinions. I can't just ask a hypothetical of a court and bring a case about something hypothetical to a court in this country. The issue must also not be moot. Which is to say, you need a case that no longer requires resolution would be rendered moot. If someone happens to who brought a case, say against the state of Arizona for something, and it goes all the way to the Supreme Court, if the person who brought the case claiming to have been harmed by the state of Arizona drops dead before the case is heard in the Supreme Court, well, then now the issue becomes moot. So there's real reason to show, you have to really be able to show harm and relevance to get a case heard. But, these things matter. Court decisions matter. As I said at the outset of the slides here, probably the last major social change that's come about through the court system is the legalization of same-sex marriage. Going back to well, I don't want to get into the details of the Defense of Marriage Act and such, but there was a lot of judicial review that had taken place going back to decisions made in the 1990s that led to the legalization of same-sex marriage throughout the 50 states in this country here. But you can see here cases filed in the U.S. by the Supreme Court. This has gone up and up and up. It's not that 10,000 cases are argued in the Supreme Court. No. And the Supreme Court's only in session from kind of early fall to early summer is how this works. But the Supreme Court clerks in particular are constantly reviewing cases and making recommendations to the justices on courts to hear. But the court, in effect, chooses to hear cases based on the preferences and priorities of the justices. The clerks that I just mentioned often reflect the political leanings and legal training of the justices. The justices are very careful in the clerks they select. But the clerks end up reading, these are recent law school graduates usually. It's usually a springboard to a very nice legal career after that, by the way. But the clerks read through everything, generate memos on cases, and then try to get justices to consider them. Any one justice can ask that a case be heard. And out of the 9 justices, they get together and they determine which cases will be granted certiorari. This is a mispronunciation of a Latin word, but it just means the certainty to hear the case. It takes 4 justices to agree to issue a writ of certiorari, which is a formal request to have the Supreme Court review a decision of a lower court. This often happens when there are conflicting decisions by 2 or more lower courts. So, if the district court federally issues a sentence that is then heard on appeal, and the appeals court decides that there was a problem with the case, and the appeals court disagrees with the district court, then that is what likely will help to get that case into the Supreme Court. And then the Supreme Court will decide, will interpret the law and issue a decision regarding the conflict between the lower court and the appellate court. So I've mentioned this already. The cat is out of the bag, but this came up in the text. How many of the 9 justices must agree to grant a writ of certiorari? It's 4 of them. There are 9 on the bench. It takes 5 out of 4, a majority to make a decision, right? So controlling the flow of cases, Solicitor General and Elena Kagan, current Supreme Court Justice Elena Kagan, had been Solicitor General prior, is an officer in the Justice Department who screens out many of the cases in which the federal government is a party. The Solicitor General decides, do we want to pursue this or not? And that's how that works. And so a lot of cases are also discarded by the federal government when it's the federal government's decision to appeal to the Supreme Court or not. But again, I've mentioned law clerks a time or two. Each justice has 4 clerks drawn from Harvard, Yale, top law schools in the country who screen the cases for the justices and assist in general legal research. They can write briefs. Parties to the case as well can write briefs. And these are not the opposite of boxers, but documents in which the attorneys explain why the court should rule in their favor. And the closest thing you can get to an advisory opinion, the flip side of the coin, I guess, is that the Supreme Court is open to what are called amicus curiae briefs. Amicus, the Latin amigo, friend. These are friend of the court briefs that are filed by those who have an interest but aren't a party to the case. After that comes oral arguments, where attorneys appear before the court, the Solicitor General for the United States government, when that's relevant, when the U.S. government's a party to the case. But you don't just have to be an attorney to present before the court the arguments and answer questions from the justices. So it's quite a bit different than what you usually see on TV or movies regarding a court setup. There are 9 justices. They all sit on the bench. The lawyers, one by one, come up and address. You usually have a presentation of sorts, and obviously everyone's read a boatload about the case at hand, and then the justices ask the lawyers questions about the case. So here, usually, no one's on trial here necessarily. They're usually trying to decide the legality of decisions made in the previous court decisions. But again, it's not the typical setup like you see on TV and the movies, unless it's specifically about the Supreme Court. But I have oral arguments here. This is an artist rendition. Cameras are not allowed in the Supreme Court. This link will take you to a quite silly thing that John Oliver did on his show last week tonight. Since there are no TVs in the court, he found dogs that looked a lot like different Supreme Court justices, and it's quite funny. It's a few years old, so some of the justices have come and gone. But if you like John Oliver, and if you like dogs, and if you're at all interested in going to law school, watch the link. It's short. But moving on with procedures here. After the case is heard, it's discussed by the justices behind closed doors, and often a preliminary vote on the case is taken. Oftentimes, especially how politicized the court has become, often it's known. There's a pretty good sense of who's going to vote which way. But then once the preliminary vote at least is taken, they start writing opinions. One of the members of the majority is assigned the task of writing a majority opinion. It's usually the Supreme Court justice, or the Chief Justice, John Roberts, when the Chief Justice is in the majority. Drafts are circulated. Sometimes people can, God forbid, change their minds, which I think is a lot easier to do when the discussion happens behind closed doors. But then the justices in the minority, any one of them is invited to write a dissent, which is how they describe how they disagree with the decision made by the court in its entirety. And then these dissents can also open the door to relitigating cases down the road, or litigating cases that are similar to the one they just heard. It's often the way to set the scene for overturning a decision. And when we get to decision making here, it's important to consider, maybe you've heard these terms, you news junkies, judicial restraint versus judicial activism, described in the Lowy text here. In theory, judicial restraint, as I say, it's this philosophy whose adherents refuse to go beyond the text of the Constitution in interpreting its meaning. This is often the view taken by folks who we call originalists, who interpret the Constitution based on the original understanding at the time it was adopted. It tends to be conservatives and Republican appointees who favor judicial restraint. And they tend to point their fingers liberally at more liberal judges who they claim engage in judicial activism, which is the notion that the court should be beyond the text of the Constitution or statute to consider broader societal implications for its decisions, right? We're basing these decisions on a constitution that was written in the late 1700s, right? A lot of things have changed. So this notion of judicial activism is very prevalent in the U.S. legal system. You tend to see more of it in more liberally minded judges and justices, but not exclusively. It really boils down to the eye of the beholder here. The liberal or conservative attitudes of justices play an important role in their decisions. That's true. It's also true that activism and restraint are not synonymous with liberal and conservative exactly, but they're often interpreted this way. You often, hear more left-leaning senators complaining about judges and justices who are originalists, and you hear our Republican friends deride judicial activism, or the term used is often legislating from the bench, is what is said by many of our Republican friends about judges they just don't like. Sometimes it boils down to that too. But this is straight out of the textbook. I won't go into great detail, but this is doesn't reflect the current exact makeup of the court, but very recently, you can see here that Stephen Breyer has stepped down and been replaced by Justice Brown Jackson, who I'm sure is in this liberal wing here. But what this indicates is the number or the frequency of times that Justice Sotomayor agrees with, who's the most liberal judge, with Justice Alito. and it stands to reason that the further you get away, the more they disagree. But that gives us a way to rank the liberalness or conservativeness, if you will, of all the members of the court, because basically we're just documenting the number of times they agree with each other or not in decisions. And you can see we've got three very left of center justices, and up to six now very conservative, well, pretty conservative justices. So the court at present very much sways conservative. But it is worth mentioning, and I don't remember exactly how. Well, it's the Martin Quinn scores here, but what the methodology is behind this. But what this does tend to show us is that over time, and this has a lot of Supreme Court justices, most of these folks are dead, but some of them get more conservative and some of them get more liberal. It's not the case that once you're on the court, your ideas about things never change at all. Justice William Rehnquist, named by Nixon, he was quite conservative initially and mellowed out. Some justices like Clarence Thomas, appointed by George W. Bush, was conservative when he started and has gotten more so. So it's worth reminding ourselves that things can change, people can change their minds, and their ideas can evolve. But beyond from that, as I wrap up here, expanding the powers of the judiciary during the 60s and 70s. Sorry, I've got some hiccups. A time of great political activism. The courts up and down liberalized standing and made it easier for citizens to sue, and thus creating more legislation and more cases for the court system to hear. The courts also broadened the scope of relief by allowing class action lawsuits. Maybe you've heard of a class action lawsuit. It's where a group of people who have been wronged in the same way by the same entity can all bring a case together instead of individually. Courts also began to employ structural remedies, sometimes retaining control of a case until a mandate was implemented. So there's a history of Supreme Court decisions, particularly like Brown versus Board of Education, that were meant to desegregate schools, but states and localities were slow to do so. So the court has taken a more active role in making sure that its decisions are upheld. But all of these are expansions of judicial power, which is definitely evolved and I'd say increased since the time the Constitution was ratified. We'll talk about this when we get together. Think about this on your own. Is the rise of judicial power, is it good for democracies? Reasonable people will disagree. Some say yes, that the courts are in a unique position to represent the powerless. Brown versus Board of Education, the series of decisions to legalize same-sex marriage, right? You could argue that. Or you could say, no, courts aren't electorally accountable and can't possibly represent everybody. Reasonable people can disagree about this and then go have a beer. But it definitely is a reality. We'll talk about it when we get together. Take care. Shut this down.